for being here on this one. First, I just want to say this out loud and on recording that CrossFit is not saying that you need to use this service or that you need to, we're not essentially endorsing this at all. I am providing a platform to give you guys information, and what you choose to do with that or not is entirely up to you. But a big part of these roundtable calls is just providing you guys with information, a place to ask questions, and possibly even resources to investigate on your own if you so choose. But it is by no means CrossFit endorsing or assigning anything for you to do. But without further ado, I want to get into what we're going to be talking about. We've got guest speaker here, Mark Rodriguez. He is you're the owner of Greenleaf?
Yeah.
Owner of Greenleaf Business Solutions, which is a payroll company, for me to kind of simplify it that way. More importantly, he's been doing CrossFit for 13 years. Is that right?
Yeah, like that's 12, 13 years. Yeah.
And has been training and trying to beat Zia at CrossFit Counterculture for 10 of those years.
Yeah.
So I really I got to have a conversation with Mark a couple of different times. And I really enjoyed that not only is he an expert in what he does, which is stuff that I know very little about, but also he understands what you do, meaning he understands the business of CrossFit. He understands the life of an affiliate owner, having been a member of CrossFit Counterculture for as long as he has, and talked to and worked with Zia through a lot of things. So while he is operating out of California, he has information and answers to questions all along the West Coast, which is where we promoted this call, and across the US. So this is definitely something that, especially if you're not here now, but watching it later, it will apply to you as well. You may just need to look into specific considerations within your state or county or whatever it may be. So what I'm going to do is hand things over to Mark, because he's essentially going to give you guys this in presentation format, which I think will be really helpful. Take some notes, write down any questions you have. I'll also introduce that he has Brianna here from his team. So she'll be able to help sort of field any questions in the chat. And if you feel that it might be better to come off mute and say that online, you can also put that in the chat, or even raise a hand, and Brianna can direct that to Mark. But we will carve out time at the end specifically for Q&A. So if you feel like it can wait until then, that's fine. But without further ado, I want to make sure that the time is safe for Mark. So Mark, take it away.
Awesome. Thank you, Katie. And thank you, Zia, for putting this together. Like Katie said, we want to make sure that this is as informational as possible. So any questions you have, make sure you write those down. We have plenty of time for questions at the end, and I'll kind of jump into it. So I just want to say good morning. It's great to be here with everyone today, not just as a professional in payroll and HR compliance, but as a fellow enthusiast and longstanding member of the CrossFit community. My name is Mark Rodriguez, as Katie said, and my journey over the last 14 years has been deeply rooted in both intricacies of employment law and CrossFit. So before we dive into the complexities of HR and payroll compliance and the critical importance of correctly classifying workers in your gyms, I want to share a bit of my background. I dedicated over a decade in the payroll and HR compliance field of my life. 7 of those years with Paychex, one of the largest payroll companies in the world. I deepened my expertise and understanding of the challenges businesses face in navigating the regulatory landscape. Today, I'm the CEO and co-founder of Greenleaf Payroll and Business Solutions. We're a leader in providing specialized payroll and HR services, especially for high-risk and underserved industries. But my connection to what you do every day goes beyond my professional role. I've been a passionate member of CrossFit Counterculture for over 10 years. Many of those years spent as training partner to Zia and Sean Patrick, formerly fittest man on earth in the 50 to 55 category. And my involvement in CrossFit extends over 12 years, underscoring that I'm not just an outsider brought in to talk to you about compliance. I'm one of you guys. I'm deeply invested in the success and integrity of our community. This shared experience is why I understand the unique challenges and pressures you face, not only in maintaining the operational aspects of your gyms, but also in ensuring that you navigate the minefield of HR compliance effectively. Our mission at Greenleaf is to empower businesses like yours with the knowledge and tools necessary to thrive in a regulatory environment that can often seem overwhelming. We recognize the hurdles small businesses encounter, especially when it comes to HR compliance, a domain filled with stringent regulations that demand your unwavering attention. One of the most critical areas where many businesses, perhaps inadvertently, find themselves at risk is in the classification of workers. particularly distinguishing between independent contractors and employees. This distinction isn't merely semantic, it carries significant legal and compliance implications. The Fair Labor Standards Act, otherwise referred to as FLSA, for instance, outlines distinct protections for employees that do not apply to independent contractors. Misclassification can lead to severe penalties, including back taxes, fines, and liability for violation of wage and hour laws. I myself have been on the hook for a 7-figure judgment against. So I can speak from experience, guys, in these situations as a successful entrepreneur. The IRS applies a 20-factor test to evaluate the relationship between worker and employer, focusing on the degree of control and independence, while the Department of Labor, the DOL, looks at the economic reality of the relationship to determine proper classification. In the context of your gyms, this means that trainers or staff who work regular hours, use your equipment, and adhere to your guidelines are likely considered employees, impacting how you manage payroll taxes, workers' compensation insurance, and other obligations, depending on your state and maybe even city. Understanding the gravity of these distinctions is crucial. Non-compliance can have far-reaching consequences, not just in terms of financial penalties, as I explained a minute ago, but also affecting your reputation, your business's financial stability, and the trust of your team. It underscores the fact that HR compliance is not merely a legal requirement, but a fundamental aspect in running a successful and sustainable business. Today, I'm here to help you navigate these complexities. Together, we'll explore the nuances of HR compliance and payroll compliance, ensuring that your gym not only meets its legal obligations, but stands as a model of integrity and success in the CrossFit community. That's the goal, right? Thank you for giving me the opportunity to share this journey with you. All right, so let's get started. So with me today, Brianna Mays, that Katie mentioned. Brianna Mays has been an employee of Greenleaf for over 4 years. And Brianna Mays is an HR consultant. Brianna does everything from outsourced HR director services to simple HR consulting, document drafting for our clients. Brianna's worked with clients that are one employee, from one employee startups to thousands of employee groups, companies that have employees in every single state across the country. So she's seen it all, and much of what she's going to talk about today and outline is from simple experience. And Brianna's based here. She's 15 feet away from me in a cubicle. So Brianna's based here in California. We're based in North County, San Diego, in the Carlsbad, Oceanside, Encinitas area. So I'm going to outline. I'm kind of going to give an outline of what we're going to go through today. I'm going to go through. We kind of summed it up to about 8 different topics that you should have in place, given that the employer-employee relationship, assuming these folks are not independent contractors. And we'll get into what that means in a little bit more detail. But assuming these folks that are working in your gym, your coaches, people that are in your gyms working every day, are employees, we're going to talk about the top 8 things you need to have in place to ensure that you're at least in compliance with that. A caveat, right? There's going to be situations where maybe you have a coach that is coaching at another gym, or maybe they have another CrossFit gym, or they're working at another gym, or maybe that's their business. There's caveats to this, but for the most part, the way the law sees it in all the Western states is that these coaches are employees. So top 8 things, I'm going to run through the list, and then I'm going to pass it to Brianna to outline in more depth. So get your pen and paper ready. All right, so number 1, compliant offer letters and the reason why that's important. Number 2, assigned job description for each employee and what that means. Number 3, making sure you're meeting minimum wage requirements by law. Really important. Once you're an employee of a company, or once you have employees of a company, you have to abide by certain labor laws. Number 4, labor law posters, making sure that the employees understand what their rights are, and you also have rights as an employer. Number 5, a compliant employee handbook that includes state and federal labor law updates. Some of these things are going to be nice to have, and we'll talk about that too, and I'll throw it to Brianna in a second. Number 6, workers' compensation insurance. In every Western state in the country, it's a requirement that if you have employees, you offer workers' compensation insurance. It's really, really important. And then the importance of having a verified I-9 on file. And then lastly, what we see clients get in trouble with often is reimbursements. Like, what do I have to reimburse my employees for? If, what do I have? What are the requirements by law? So Brianna, excuse me, Brianna, I'm going to throw it to you. But before we do that, I'm going to take a risk here and open it up for questions to see if anybody has any questions thus far, because we're doing great on time.
Could you put those top 8 like maybe in a list in the chat? I got most of them, but some of them I don't know if I wrote them down properly or whatever.
Absolutely.
I was
Absolutely.
also going to second that and say, do you have slides for that so we can remember which ones you're talking about?
And we'll get a full breakdown to you guys after the call as well. And Brianna's going to go back through them right now. So she'll go through each one by one. Good questions though. Absolutely. Brianna, are you ready?
I'm ready.
All
Hi,
right.
thanks.
Ready, set, go.
Thanks for the intro, Katie and Mark. And hi, everyone. I'm very excited to be here as well. So, Mark explained my role here at Greenleaf Business Solutions. I've been in HR for about 8 years right now. I think the biggest blessing being at Greenleaf is, like Mark said, is when it comes to HR, having the visibility to all 50 states. When it comes to HR, there's so many different layers. So, what my ultimate goal and objective today is to be a resource for you on this call. So, please, as I'm going along, if you have any questions, go ahead and fill them in the chat. I want it to be more of a conversational piece rather than me just kind of drilling down on these points with more information. So if any of these things that I'm going through intrigues you regarding your business, go ahead and please raise your hand, put it in the chat, and then I'll go ahead and stop. Awesome. Okay, so let's get into the first topic. So the first topic is offer letters. So whenever it comes to employing employees, the biggest thing that employers aren't aware of is that the liability starts from the moment that you start recruiting. It's not once an employee has signed an offer and that they're through the door. So when it comes to the offer letters, it's important to have a compliant offer letter. What does that mean? So the offer letter should include details as far as what their anticipated start date should be, what the expected pay range or pay rate should be that was discussed during that recruitment, so that it's very, very clear once that employee has been onboarded, if they try to come back a week, 2 months later stating, hey, I was paid incorrectly, that you have a formal document that indicates what that rate of pay is with a signature from the employee. I think another thing that I see in my experience is that an employer will push out an offer letter and not track down and ensure that they receive a signature before that employee's first day. So that's going to be definitely the first thing when it comes to the offer letters. The next thing is benefits. So within that offer letter, any type of benefits that your business includes for employees should be clearly outlined. Examples of those benefits would be health insurance, if you offer any type of sick leave, paid time off or vacation. Anything that's going to be negotiated during that recruitment process should be clearly outlined in that offer letter as well. Again, as protection from your business, so an employee cannot state that they were misled during the recruitment process. The next thing during that offer letter should also be the FSLA classification. So this is also something that Mark had mentioned. So that's going to be your non-exempt or exempt. So kind of to break that down a little bit further, non-exempt is typically associated with an hourly employee, and exempt associated with a salary employee. So that's also going to be really important to classify that, just again, in case an employee is not taking their proper meal breaks, rest breaks that are required by federal or state law, that you have it very clearly outlined that there shouldn't have been misinterpretation because they were identified as non-exempt hourly. And then the last thing that I would mention for those offer letters is contingency. So what contingency means is if you have an offer letter and you're saying, by accepting this offer, it is contingent upon you passing a drug screen or a background check. So what happens is employers will not include that in an offer letter. Employees will sign off on it, then they'll process that background check. And if it comes back with any red flags that are non-negotiables for your business, you want to make sure that it's very clear in that offer letter that you inform that employee if any of those things do not come back properly, then that is going to be where you rescind the offer.
So Brianna, is it required that gyms do a drug screen or a background check?
No. So the background check typically depends on which city, county, and state that you're in. Again, there's levels to those as well. Normally, it's dependent upon the sheriff's office and what they dictate. But for the most part, it's not very common for background checks or drug screens to be required.
Yeah, and I would say that for the most part in the gym and in the CrossFit gym environment, you're not going to have many. There won't be many exempt people that we've associated as salary employees in the CrossFit. You're in the CrossFit gym environment. You're going to have more unless you have a full-time coach, right? So, but if you have questions on that, if you might be in that position, we can go into that during Q&A later.
Perfect. I think just to kind of touch on the classifications for non-exempt hourly, like I mentioned, for the meal breaks and the rest periods and punching in. So if you do have employees that are hourly, that's going to be the other really, really big push for your records and documentation is ensuring that those employees are using some form of a system to clock in and clock out, tracking their rest breaks and their meal breaks if they're hitting that 6 hour plus shift mark, just in case they decide, they don't end on good terms, they want to go file a labor law claim, that you have some type of documentation proving that those employees were clocking in and clocking out.
Can I touch on something too there on the classification of workers? Where we see a lot of businesses, not just CrossFit gyms, get in trouble is when they have when they have contractors misclassified as contractors other than employees. Those contractors go to get unemployment insurance. They go to the EDD in California. Every state's government governing body is a little bit different, named or acronym. They go to file for unemployment, and that contractor says, I worked at ABC gym, and then when that governing body goes in, they don't see any employment record of that no employee record. They don't see anything, so they reach out to you. That can trigger an audit, that can trigger a DOL investigation, like the list goes on. That's typically how we see some of these things going with misclassification of employees. And essentially, as the employer, the onus falls on you, right? And the unfortunate world of being an entrepreneur, especially in kind of the Western states, is that you're guilty until you can prove yourself to be innocent in terms of the documentation. And that's why some of these things are really, really important.
Yep. And Zia made a really good point. So, specifically for California, again, it's going to be different for every single state. In California, if you have employees that are working directly with children, that is when a background check is required. Awesome. Okay, so let's keep moving along. The next topic is still kind of closely aligned with recruitment. It's job descriptions. So normally when you're going through your recruitment process and you extend an offer, the offer letter should be presented with the job description so employees can review what's expected of them within that role before they sign and accept that offer letter. So the importance of a job description, again, it's really important to put time into those job descriptions to ensure they're aligning with the expectations for that role and your operations. It's going to include what the job responsibilities are, what the qualifications are for the roles, and then within those qualifications should include the weight limit. So specifically for the gym industry, what's most common is anywhere from 25 to 50 pounds. But again, that's something that might need to be reevaluated. And the purpose of that is if you have an employee under ADA that might have a back injury or, a medical condition where they cannot lift heavy amount of weights, you want to have that clearly identified in that job description. So as they're reviewing, they can see that and say, okay, well, I can only lift X amount of weight. So maybe this is not going to be the best position for me. Obviously, there's a whole other avenue where they is going to take you down to reasonable accommodation, but that's going to be the first line of defense right there for them to identify if this is going to be something that they can commit to if it's outside of their health restrictions. The other thing within the job description, how it helps you as a business owner, is employees from time to time will say, hey, I was asked to do X, Y, and Z, and that's not within my job. So that's going to be a really good indicator that you're saying, hey, this is a job description that you signed, and you can see one of the bullet points as your responsibilities was to clean the windows or to clean the gym equipment. So that's going to help you as you're having those conversations to before it gets to termination or before it gets to an employee filing a labor law claim, is just to have a reset and show them that this was identified during the recruitment process and you signed and agreed to it. The other thing within the job descriptions that we like to include at the very, very bottom is any other responsibilities as assigned by supervisors. Obviously, when it comes to a job description, you can't just throw everything in there and anticipate what you would want that employee to do, but you're going to have the core responsibilities and then have that little bit of a blanket at the end so that as a supervisor, as an owner, you can go ahead and request what's reasonable within that employee's job description. Awesome. Any questions about job descriptions and the purpose? Pretty easy. Okay, let's keep moving along. The topic number 3 is going to be minimum wage. So I know we kind of talked about possibly having contractors, but we're going to focus specifically on the employees, and then I'll get into the independent contractor test a little bit more in depth. So minimum wage is going to be different for all different states. And what you're responsible for as an employer or supervisor is to ensure when you're onboarding an employee, you're meeting that minimum wage requirement for the city, state, or county. What happens is if you have typically in the gym industry, I know some coaches will do per class, which is totally fine. So if you have any type of employees that are being paid X amount per class, the only requirement then is that you total up the amount of hours an employee worked in a pay period, and then ensure that the amount that they were paid per class is equivalent to at least minimum wage. So what that means is if employees are paid $50 per class and they worked 10 classes within a pay period, $500. So for California, that's $16 an hour. So you would basically take the 10 hours times 16, which is $160. That would be the minimum that that employee would have to make in order for you to be in compliance. The other thing, when it comes to minimum wage, there's also a separate minimum threshold for our exempt salary. I know we mentioned in the gym industry, there's not typically many salary exempt employees, but I want to cover it just in case you have questions. So anytime you're making that jump from non-exempt to exempt, hourly to salary, there is then a threshold there. Again, it does vary from state to state. For California in particular, theirs is 60, just updated for California, it's 65,560. So again, that's really helpful as an owner if you're trying to make that adjustment. Let's say an employee's accruing a lot of overtime, a lot of weekly double overtime, and you're like, okay, it probably would be more cost beneficial to me to move them over to a salary. It's not just that easy. You have to make sure that they're eligible to be classified as exempt and make sure that you're willing to pay that minimum threshold. Okay. If no questions there, let's go a little bit segue into independent contractors, just in case anyone might have anybody identified as a contractor. So previously in 2021, they released, it was called the ABC test, and that's how employers identified if an employee would be eligible, or excuse me, an individual would be eligible to be classified as a contractor instead of an employee. Lucky for us, the federal government just updated it January 2024. It's now been updated from 3 points to 6 points. And the purpose of this is the federal government wants to make it really difficult for employers to classify individuals as contractors because then they don't get paid their taxes. So those 6 points really identified are ensuring that, kind of Mark indicated in the beginning of the conversation, is that a contractor is free of control from an employer. So what that means is you cannot dictate the hours of operations. You cannot dictate how many hours that contractor works. So that's going to be the main point of contact or point there. The second one is all of the tools and resources that that contractor uses to perform their responsibilities cannot be reimbursed at all by that employer and cannot be provided by an employer. The third one is going to be profit or loss. So profit or loss basically means that regardless of what work they're performing, that any type of loss or profit is going to be taken by them. As an employee, they have a set rate of pay, set salary, so there will not be a profit or a loss for them. It's going to be very, very standard. Let me go back to 6 points just because it just updated. The other 5th point here is going to be skill. So that's the other thing is typically when you're hiring an employee, you're not hiring always off of skill just because you can train up, you can coach up. When it comes to a contractor, normally that's something that is a very individualized skill that they have and then they're bringing to your business to benefit your business. And those are going to be like the main points for identifying a contractor. It's really important to kind of comb through those and make sure you're having that conversation for your business so you're not misclassifying. Like Mark said, is if that does happen, you can be audited by the government. And if they find that that employee or contractor was misclassified, then they can go ahead and reap all of the back owed taxes.
A couple of things too to keep in mind with independent contractors is, as we know, that's been a fairly common practice in the CrossFit community, is that a true independent contractor should carry their own general liability insurance in their own name, right? Or their business's name. They should also be invoicing you for the hours that they're working. And you really should not be doing any kind of direct deposit or electronic payment for them. It should be handled like they are a vendor of yours, like they're beverage vendor, they're a protein vendor, whatever the case is, like very similar, should treat them very similar to that. That's a huge step in protecting yourself if in fact you feel that you truly have independent contractors there.
Awesome. Okay. If no questions on the contractor test and the
I
minimum
have
wage,
one.
we
So
can.
there's pretty much no way that any gym should be classifying CrossFit coaching in any way as 1099s. They are 100% employees.
They
Just to make
should
that
be,
crystal clear.
yeah, they should be employees because kind of going back to that topic about
Yep.
dictating their schedule. Your classes are going to be what you dictate. So then they would have to show up for those very specific times.
And this isn't us making this stuff up. Like this is state and federal government that's saying these things. And then there's legal precedent that says, yep, you know, you don't really have ground to stand on as a business owner to argue this any other way.
Okay. The next one is labor law posters. So kind of just getting into what's required to be posted and presented to employees. So for all businesses, regardless of your size, you're required to post a labor law poster. That labor law poster is going to include all federal requirements and state requirements, and sometimes even county requirements, depending on where you're located. So like Mark said, is that's going to be all of the employee rights. There's a lot of good information, such as like your worker comp representative information, where to reach out to if there's a non-emergency, and all of their rights as far as for like California. I know that there's specific rights for like pregnancy disability and so on and so forth. So what's required of you is to place that in a common area where all employees always have easy access to. What happens from time to time is I'll see clients will post it up in, a manager's office. If employees do not consistently go in and out and have easy access to that, let's say there's a lock on the door, then that's not considered compliant. For locations, if that's not an option for you, sometimes you can place it in the bathroom. Another option is to send it out electronically where it's posted where employees can easily download it and view it at any point as well. So whenever it comes to labor law posters, those are released usually in the beginning of every single year once they've done the updates. Throughout the years, there are always, every single year, going to be federal or state updates. When those are released, they do come with effective dates as well. Once those are released, it is then also your requirement to download those updates and then post them right next to the poster. What can happen is if you were ever to be audited and they find that you are not complying you could be subject to penalties. The other thing is obviously employees knowing their rights. If they are at the work site and they see that it's not posted, they can then file a labor law claim against the company as well for not being compliant there. So
And can I just pause really quick on that?
Yeah.
Here's the thing about labor law and payroll and HR compliance. These are the laws, right? But just like speeding down the highway, going 120 miles an hour down the 5 freeway, that's illegal. People do it all the time and they don't get tickets, right? So this is not meant to scare. This is not meant to scare. This is just the reality of the beast of being an entrepreneur. And if you can execute on doing these things consistently and build them into your process, just like you do everything else, it will significantly mitigate any risk of an employee saying or claiming something against you or your business. So I just want to make that clear and have that as a caveat, is that these are highly suggested, but once again, speeding on the highway is also illegal. Doesn't always mean you're going to get a ticket.
Thanks, Mark. Okay, any questions on labor law posters? They usually call them all-in-one labor law posters. They can be found all over the internet. Like I said, they are all fully updated as of the first week of January. So anywhere you purchase them, they should be good to go. Awesome. We just keep an eye on the chat here. We're all good. Number 5 is going to be employee handbooks. So I know Mark mentioned what's required for a business owner versus not required. An employee handbook is something that is not required to be produced as an employer, but is definitely highly recommended as best practice. An employee handbook is normally around 50 plus document, and it has all of the federal requirements for policies and then all of your own location operating policies as well, and then additionally your state ones. So the reason why the handbook is so important is it's that frontline defense for you as an employer when you're onboarding someone, that gives them the rundown of what's going on in your business. So that handbook is going to tell them what they're eligible for as far as benefits, PTO, sick time, help them understand all of the federal leave of absences that they might be eligible for. And it really provides them with all of the information that they need to understand as far as their rights. And then it helps you on the back end as an employer, just because it aids in assisting you with the disciplinary process or termination process. So an example of that is attendance. So if you clearly outline your attendance policy within their handbook, there should be no room for misinterpretation. So if you have an employee that's consistently showing up late to the scheduled classes and you're having those conversations, and then you're like, okay, we've gotten to the end of this and we really need to just move along and separate from that employee, you're going to have a signed employee handbook where you're saying, I clearly outlined what our attendance policy, and it says by that 5th occurrence, it's going to lead to termination. So if that employee says, oh, well, it wasn't very clear, you're like, no, here it is in the handbook. So that's the reason why I think that it's very great to kind of have those brief documents to provide to employees, and then updating every single year so that there's no room for error. Any questions on employee handbooks? No, all good. Okay. Number 6 is going to be workers' compensation insurance. And Mark mentioned workers' comp, that it's required for majority, almost all states, if you have even one employee. So basically, the purpose of workers' comp insurance is just to protect you as a business. If you have an employee that's injured on the job, what the requirement of you as an employer is to report it. Even if that employee slices their finger, they wrap it up and they're like, no, I don't need any medical attention. The requirement is that you still report it, and then that employee declines any type of physician or to be looked at. So the reason why you have to report those is directly for the state and the federal agency for OSHA, to ensure that when you are audited, that you have a list of all of those work-related injuries reported, and then they will follow up with all of the claims to ensure that you follow the correct protocol. Again, the reason why we're kind of talking about this is if an employer does not have workers' comp insurance, if an employee is injured, you don't have that protection. So an employee, again, can then go to the labor board commissioner and try to have a conversation about how they were injured and that the correct steps weren't taken, which could lead to penalties. So we do assist with that, kind of getting you the information as to what are the best insurance brokers so that you can have that information. Majority of the time, if you're following all of the correct procedures, you'll never have to file a claim, just because you're focused on safety and employees will never be injured on the job. But it's a nice little backup just to have. Okay.
I've got a question.
Yeah.
We're talking about a lot of the things, and it's kind of made me I thought of this because Mark was talking about speeding on the freeway. Well, we talk about penalties and oh, you have to have this, you have to have this. Do you have guidelines or hey, what is the penalty? You're an employee takes action. I don't know what that means.
Yeah.
Yeah. So, oh, sorry, Mark. And so for some things, it really is cut dry, where it's saying for this occurrence, this is what the penalty. For some things, what happens is they'll get escalated over to the labor board commissioner. Then the labor board commissioner will say, okay, let's go ahead and tack on this fine. And then you're additionally going to get these fines and these fines and these fines. So it could vary depending on the situation. And I can go ahead and look into our resources to see for these different things that we're talking about, if it really is a cut dry penalty or just the initial penalty to be aware of. But like Mark said, it all is dependent upon if you were to be audited.
Yeah. Well, here's the other thing too. That's the thing, the where I see it most often is where the employees misclassify the employee as an independent contractor. You terminate them, they go to file unemployment. That triggers an audit from the development department of your state, the employee development department of your state. And then they come back and go, hey, this employee says he's worked here for 2 years at your job. He's earned this much in wages, and we don't have any state payroll taxes for this employee. And they'll go back and they'll do all the calculations on the employer related taxes to those wages. Additionally, that will then trigger them to come in and say, let's see their I-9, let's see their employee paperwork. And then those things have very specific fines associated with them. For instance, I think the I-9, not having a correct I-9 is $50 a day in certain circumstances. If you don't have it filled out correctly, $50 a day per I-9 per employee. And if that's going back to 2 years to their initial hire date, these things start to get insane. We're talking, insane amounts of money, and it's hardcore. I've been on the receiving end of this myself, so like I can tell you for certain it's not fun. So like I think it's Colby, but yeah, Colby, like some of these things are pretty hardcore and gnarly, and the government just doesn't care. They just don't care, unfortunately.
Remember that hair salon that got caught using 1099s for their hairstylists instead of W-2s? And she was open for 10 years, and one of them tried to file unemployment. She got caught. They went back and looked at all of her books. She had over $2 million in fines. She went bankrupt, and she never recovered from it.
And these are worst case, that's a good example, Zia. And these are worst case scenarios, right? These are worst case scenarios. Oftentimes how it gets to that point is the employee will say something, they'll make it clear that something's off. You'll have warning signs before it gets to that point. And if you are in that position, what I would suggest that you do is seek legal representation immediately. And whatever that employee might be asking for, like look to settle that right away, even though you may be in the right. You feel like, hey, I have all this stuff, I did all these things. That's just the nature of like litigious world we live in. And you know, there's resources out there, whether you're looking at doing something with us or a number of companies, you can even do it on your own. But some of these things are like the basic documentation you definitely want to have in place.
Good
So I just
question.
did like a quick little Google search for like the I-9 thing, and it says a maximum penalty is $2,500.
For that could be for the auditing, and then once it gets down to legal, there could be additional fines on top of it. So specifically for the I-9, what happens is ICE, that's going to be topic number 7 that we're getting into, is ICE will come in and do an audit. So ICE will have the penalties that they'll assess, and then from there it could become additional fines once it's legal.
Cool. Yeah, that's like all super helpful, because it's great to say like, oh, you have to have out all this stuff, but it's also helpful to be like, if you don't, like these are the actual ramifications, instead of saying like, yeah, I mean, you said it before, you're like, we're not trying to like just scare you. So the way to like not scare somebody is be like, hey, these are what the actual penalties look like if they're laid out.
Totally. And that's the thing too, Colby, is it's not always clear, right? The government has a lot of ability to kind of use whatever information they have in your files, whether you have the documentation or not. And if they determine that you're willfully negligent, then they can tack on additional penalties. And what willful negligence means is that you acted in willful negligence, meaning you knew better and you still didn't follow the law. And they are highly aggressive in situations like that. And in any case, it's never good. It's never going to be good. Oftentimes what we see is when employers get to this point where the DOL might be involved or an employee's gone to the EDD and you have these investigations and audits that start to occur, there are always daily fines associated to documentation that's not filled out properly. There's always daily fines going back to the start date of each employee. There's always misclassification penalties in terms of missed taxes upon wages that were already paid. And these things are paid back, not only dollar for dollar, but with penalties and interest on top. So it's just it's a nasty beast. It's a nasty, nasty thing.
Yeah, great.
Difficult to quantify, Colby, like difficult to quantify, but it's just to give you a heads up, like.
Yeah, but I think that's a good note too, like understanding what the baseline penalties would be, just so you have a clear understanding. It's a good point. Alrighty, so that's kind of segue into the topic of I-9. So once an employee is officially starting, so that is their first day of work. So sometimes what happens is they'll have an employee start date as the 8th, but then they won't be hired as the 8th, but they won't start until the 10th. So what it's going to be is the very first day that they work, you have 72 hours from that day to verify that they're authorized to work in the United States. So there's a I-9 form that we are probably all familiar with. So that is what the immigration office, so if you ever were to be audited, would come and look specifically for those completed documents. So what happens is you want to go ahead and have that employee bring in their eligible verification documents for the I-9 on their first day, or again within that 72 hours. And what they require is that you have to visually in person verify that those are eligible documents before you complete that document and sign off on it. Another option is e-verify. So what happens is some individuals are like, okay, well, I'm looking at a social security card or a passport, but I don't know if it's a legitimate document. So that's the purpose of e-verify, where you're putting in the information and you let the government do that job for you to say, yes, this person is authorized to work in the US. From there, you still are required to fill out the I-9 document. That's just a second layer of defense so you can ensure that you're compliant there. What happens is sometimes employers are like, they get backlogged and they find that they miss that 72 hours. Again, it's not the end of the world. You can still go ahead and verify that document. There is a comment section there where the best practice is to indicate the reason as to why you're verifying it outside of that 72-hour window. Again, in case you were to be audited, you're still able to produce those completed documents. But what they're looking for is that signature date and ensuring that you have a comment section to identify the reason why it's past the 72 hours. If for whatever reason you hire someone and let's say on the second day work, they produce the documents and they are unauthorized to work in the United States, then that is going to be your key indicator to terminate their employment effective immediately. So when it comes to reporting all the wages, you would still want to ensure that you're paying those employees. So what happens from time to time is an employee doesn't have a social security card, an employer finds that out on day 2, they're not authorized to work and they're saying, okay, well, I still need to pay wages. So again, you still want to go through the normal process of grabbing a or state withholding form and a federal withholding form. So you're pulling out the correct taxes and then paying that employee, but just ensuring that you have a document saying that you terminated effective immediately once you found out that employee was not authorized to work in the United States. It's not very common that this happens, but it's important just to know those steps in case it ever does happen to you. Awesome. The last topic here. Oh, we have a question, Aaron. I-9 documents. Do we need to keep a file of these documents on hand or just a signature and a date on that I-9 form that says that we've been verified? Great question. So you used to have to keep a copy of the verification documents. You no longer need that. So as long as you just have that I-9 form that's completed with the document information on it, then that's sufficient.
And it's suggested that you do not keep a copy of the documents, because if those documents are fictitious and you house those documents, then you could essentially, the government sees you as liable for fraud, essentially, or you could potentially be classified as knowingly working with fictitious documents. So highly suggested that you do not keep copies. If you have those, I would probably get rid of them. Best practice.
Okay. And the last topic is pretty simple, just reimbursements. So the way it works is when it comes to reimbursements, anything that an employee would need to perform their job should be reimbursed by an employer. So an example of that, let's say that you have very specific instructor shoes that you're saying in order to be an instructor, you have to have these shoes that are branded by CrossFit, then that would be an example of something that an employee can purchase but would have to be reimbursed by the employer. There are a few caveats here. So we talked about that contingency. So you could say that your offer is contingent upon you owning 10 pairs of black spandex in order to perform your job. So that would be fine, but it's anything past their job that you're requiring of them, anything that is branded to your company, then that is something that should be reimbursed by the company. There's other things that where you can say, okay, well, the company will automatically provide, three shirts. Anything outside of that, if you lose these shirts, then you have to pay outside of that. That's perfectly fine as long as you have a very, very clear policy that states that. Let's say employees are just damaging their shirts left and right. Again, the company is not going to be on the line for paying for shirts every single time they damage a shirt. Any questions on, oh, I forgot to talk about, that's kind of about the uniforms. When it comes to the workout industry or the workout industry, the other thing that tends to happen is utilizing personal devices. I don't think that's too common, but if you do have any supervisors that are using their personal cell phone for the company use, that is also something that you would want to take into consideration to ensure that they're receiving some sort of stipend. There are two different methods. So usually what happens is an employer can identify what percent that employee is using it. Let's say 50% of the time they're using their cell phone. Then you can dictate what 50% of their cell phone bill would be. The only issue there is that employee would have to submit their cell phone bill every single month. That could be a little bit tedious. The other one is just identifying a set amount. So you're saying, okay, we understand that if you're utilizing your phone 50%, that should be about $40 every single month. That should cover 50% of usage. So then at that time, you can go ahead and set that amount and tell employees. If that doesn't seem accurate to them, then at that time, they can submit their bill for you to reevaluate their amount. So just taking those into consideration. There are some ways to slightly get around that as well. For phones, you can download separate apps to ensure that they're using a company generated number instead of their personal cell phone. And then that'll assist you with paying a little bit less just because it's utilizing the app versus their cell phone, and they can shut that off during certain hours. Any questions on reimbursements?
I don't know if this is considered reimbursement, but if you have an employee, technically job certifications, where would that fall? If we require, for example, it's required to have an L1 to be a coach, but it's not required to be an L2 or an L3. I have always I pay for L2s and L3s because I require it, but if they're I have employees, so I incur that cost. Is that generally best practice, or can a CrossFit require their coaches to be at least an L2 or an L3 and at their expense?
Yeah, it's a really great question. So what it boils down to is what's the requirement overall for that position. So if you're saying across all of CrossFit, it's like you said, the L1 certification, but specifically for your location, it's L2 and L3, then you can go ahead and adjust that when you're recruiting and saying specifically for this location, our coaches need to be an L3. So then that would be considered your contingency for the job.
But what if like you hire them as an L1 and then you're like, I need you to be an L3 by the end of
Did you build that into
2
the job
years?
description that like L1 is
So if I just need to build it into the job description.
and
So
by
if you,
next, yeah.
oh, sorry, Katie. If you hire as an L1 and that's your requirement for the L1 is that they just have that certification, but then you're utilizing them for, let's say, a promotion or another job, then that's correct. You're doing the correct process is where you would be incurring those costs because you hired them saying, okay, as an L1, this is a certification that you need. But once they were brought on board, you're saying, okay, well, now I need you here. So had you during the recruitment process said, in order, throughout this process, eventually you're going to get here. So I need you automatically certified as an L3. So we can start you off as an L1 and then 3 months later, you're going to be as an L3.
Okay.
So it's all about the recruitment process and what you are transparent about.
Okay.
I think something that might help with that question is I build this in my job description is when the L1 is up for renewal, and L2 has to get replace it instead of an L1. So that it's not like it's part of their job description, but it's not like, hey, you're up for renewal on a certification either way. The cost is no different. If you want to be employed, you have to have this. You'll have to get a level 2 instead of a level 1.
It's mostly the L3s that are tricky.
And then who incurs the cost of that? So who incurs the cost of that? Are you guys as trainers incurring the cost of that? It sounds like you are.
I
Right?
pay,
So, like,
I pay for
benefits,
the.
I feel like that's what you would list in benefits because all the affiliates I've talked to, it varies. Some pay back 100%, some reimburse up to half, some it's a little bit in between, and some will do things like I will have them pay the entire cost, and then over a 6-month period, I will reimburse in their paycheck so that they have to stay before I reimburse them, essentially. So I think maybe that's where you would list that in the benefits. It would be that I
and the offer letter.
Yeah.
I do something similar in my job descriptions for us is basically if you're with us for 6 months, then every calendar year they get $500 credit towards continued education, and it's just a requirement. If you're not continuing education, you're not going to be an employee here anyways. But like that's how like as long as that's kosher.
Yeah. I like that.
So similar question, if we are requiring them to like complete a course or get a certification and it wasn't in their original offer letter or job description, do we need to reimburse both the cost of the course and certification and their time spent to do it?
Yeah, it's a really great question. Yes. So the answer to both of those is yes. So just because it's utilized to benefit the company. So if it was not discussed as a contingency during the recruitment process, they're now employed and you're stating you need this certification covering the cost. And then if they're not doing it on company time, it's outside of company time, reimbursing them at their hourly rate for the amount of time.
Wow. So definitely build that into the job description is what it sounds like.
Yeah,
Yeah.
the
Yeah,
offer letter is probably what I would recommend more. If you guys have it in your job descriptions, no need to rework those. But anything like you had mentioned, Katie, the point is for the job description, those are more so responsibilities that are pertaining to that role. So if it's anything where you're saying, you know, hey, in 6 months you're going to be promoted to this position and this is going to be the requirement, you don't want that to be in the original role because again, that pertains to that role. So within that offer letter, you can state, you know, along this process, if at any point you were to be promoted to a new role, you would then be entitled to those requirements of that role. So then you can have that specifically in that job description as one of the qualifications. And forgive me, I'm not too savvy with all the language, but let's say it's a L1 job description and an L2. In that L2, the qualifications would be that specific certification. And then in the original offer letter, helping them understand as they're promoted, they're required to get those specific qualifications.
Then you're not on the line to pay for their time. And if you didn't specify benefits of paying back, you wouldn't be on the line for that either.
Correct. As long as it's outlined clearly in the job description and the offer letter, then you're perfectly fine. It's any point where it's not communicated and you're then requiring it of them. The only
Anything
thing is the
retroactive?
time would, oh, go ahead.
What if you've already hired people at this point? Is there anything that can be done retroactively?
yeah, that's what I was gonna ask is what are the rules around updating job descriptions?
Is it time to move everyone into a new job description now that you realize there's some things you could clean up? Like, what do you guys recommend?
Yeah, so we just say it's like a revamping. So what happens is communicate to your entire staff. At this time, we're going to be assessing our job description, seeing where we can clean a few things up. And then once you revamp it, normally your job description should have an effective date in the top right corner. So you would go ahead and update all of them, create that effective date, and then roll it out to employees to sign off on. You don't want to include anything that's like totally drastic where you didn't require it and now you're saying this is going to be a requirement of the job because that could ruffle some feathers and employees are like, oh, well, had I known that, I wouldn't have accepted this job. So as long as it's reasonable, then yes, you can go ahead and update those job descriptions and re-roll them out.
Something as simple as if you haven't written this down, like you need to maintain a current credential, right?
Yeah.
That's if that is in the job description, then that's all on them. If you are, like some of you were saying, expecting them to continue with upping their credential, or maybe level 2 is the cap for you, maybe you expect everyone to just keep going, just outlining that, right? And maybe there's a timeline in there, maybe there's not, I don't know what's recommended, but okay.
Yeah. Just as much transparency as possible, helping them understand their expectations.
It's not out of line to just be like, we're gonna do a little overhaul, a little revamp, and people sign here.
Yep.
That's
Yep.
And
Operations are always changing.
the beginning of the year is a great time to do that too. So I think employees in most industries come to expect that around this time of the year.
Yeah, I renew all my staff contracts January of every year.
well, I know we're running a little bit low on time, but I don't want to miss out on any questions. Emily, I know you and I had spoken before. Do you have any other questions that you might, or that didn't get answered? Unrelated, necessarily related? I don't know.
I just wanted to clarify the same topic. So specifically for us, many of our coaches had like first aid, CPR certifications at the time that they were hired. But as I'm going back and like looking at our job descriptions, I want to update and make it clear that it's a requirement that they have it and a requirement that they maintain it. So if I were to update the job descriptions, make that language explicit, and one of our employees was like, oh, I don't have it, or mine's expired, are we on the hook to pay for the time and the cost of doing it? Or if they sign that job description with the updated explicit language, is that now their expense on their time?
Yeah, it's a good question. The CPR is a little bit different than the topic about the certifications because the CPR was what you said you had to have in order to have a job. So that's going to be a document or excuse me, a certification that they don't have to keep going up. It's just maintaining the compliance there. So the answer to your question is you can go ahead and add that to the job description and have them sign off on it. But being that you required it at the very beginning of their employment, they are still required to maintain that and pay the cost of it themselves. So as far as paying them for the time that is used to complete it, that is optional. Like I said, I would recommend if it's benefiting the company to go ahead and pay them for the time that's used, but it's not a requirement.
Yeah, I think it was one of those things that it was like, it was maybe verbally discussed and it was an oversight in our job description. Or in some case it was an assumption because we had just started. So we're trying to formalize it, and there might be a case where like there's nothing in writing from their initial hire paperwork, but we're trying to correct all of that, like for our existing staff and for anybody going forward.
Yeah, or even a policy works too. If you're finding that that's a requirement for all employees, you can kind of just do like a CPR certification policy where you're outlining the information saying, A, you know, you will not be reimbursed for it because it is a requirement of the job. However, as an incentive, we will reimburse you for the time spent to be certified. So it's just whatever you guys decide operationally.
Yeah, we already have a if you're with us for 60 days, there's a $250 continuing education allowance that people can
Oh,
use.
nice.
So yeah, we've been trying to clarify what do we have to pay for in addition to offering that allowance. So it sounds like if it's something we require after we've hired them, after they've signed a job description that wasn't in that initial paperwork, then we're on the hook for the fees and the time. But if it's in their job description, in their offer letter, in our employee handbook policies, they've signed that, then it's not on us.
Correct.
Okay. Thank you.
No problem.
Thanks, you guys. I think that's really helpful. Zia was just mentioning there's some good online ones, and the partner network has a deal on that. I did that one most recently myself. You can do the CPR AED, or you can also tag on the first aid one if you'd like. As
Yeah,
well.
it's the longest.
Makes it
It's
so
long.
much longer if it's first aid, but hey, they know how to wrap a wound.
But they automatically send it to the L3 board, so.
Yeah. Well, we're almost at time. I don't know if Brianna or Mark had anything else they wanted to say or wrap up with.
No, just thanks again, Zia and Katie, for the time today. Like we said, this stuff is really important to make sure you're mitigating the most risk. It sounds like a lot of you guys are really taking the steps you need and have at least put a thought into it. So I think that's where it starts. There's a million different resources out there that you can leverage to get this information. We just encourage you guys to do that as much as you can. And just thanks again.
Awesome. Thank you guys so much. I will have this call living on our YouTube channel. I'm also going to send out an email with everything that we've talked about for anyone that registered and didn't attend. I'll also throw in a little bit of stuff that to check out. There's free webinars outside of Greenleaf. There's also, you can check your county, your state for helplines and things like that. It by no means has to be this, but also we'll have Mark's contact info if you'd like to follow up with him on anything. So we thank you all for attending. Appreciate it.
Thanks,
Bye.
everyone. Have a great day.